Thank you for joining me this afternoon. I think I might possibly have chosen one of the warmest days of the year to do this, so I do apologise if you have urgent gardening or something else that you would prefer to be doing today. I will try and keep it fairly swift moving. This is the third of our series of inquest sessions. I'm hoping some of you have joined us for the earlier ones. If you haven't and you are interested, then please do let us know. My colleague Ridwan Omar opened the series on the 6th of May, and he covered the rules and regulations surrounding inquests, and he also provided a COVID-19 update on that occasion, because that has just been published by the Chief Coroner. So if that's something that you are interested in, please let us know. Last week, my colleague John Miles also covered a session. He was looking particularly at inquest conclusions and also some of the more specific things that you might need to know surrounding Article 2 inquests. So again, if that's something that you would like to catch up on, please let us know. Today, it falls to me to cover Evidence and Regulation 28 reports. I'm going to do it in two separate sessions, but they run back to back. You don't need to log in or out. I'll just give a very small break in between for you to catch your breath. The evidence section will run from now for about 30 minutes, I'm hoping, and then the Regulation 28 session will be the remainder of the time. I'm hoping to be wrapped up in less than an hour, hopefully about 50 minutes. So we'll see how we go today. I know it's sometimes quite difficult to keep listening and keep holding your attention for so long. So I'm hoping the slides keep you occupied as we go along. Okay, so just see if we can get the slides moving. Here we go. So the first section is going to be on evidence, and I just thought I'd take you through some of the things that you might need to know, that you might find helpful to know. A few facts, first of all, and just to put you, give you a better picture really of what the coroner is dealing with. About 50% of deaths in England and Wales are reported to coroners from various sources every year, maybe from health, police, community sources, and they open between 500 to 600 cases every year. So at any one time, a coroner will have a rolling caseload of about 400. Now that's quite sizable, and they don't have an awful lot of background assistance. They run on a fairly skeleton staff, really. And in addition to all of that, the coroners are on call 24 hours a day. So I only put that out there just to make you aware that if you are asked by the coroner to give evidence, then the more you can assist him or her, the better received you are likely to be, because they are extremely busy people. Few facts that might be good to know. The coroner is the equivalent of a circuit judge, albeit that the court setting is less formal than in many courts. So some things you would find familiar if you've been in a courtroom before. You would address the coroner, for example, as sir or ma'am, and you would address them appropriately in correspondence by their given preferred title. But the coroner will not wear a wig and gown. They'll be smartly dressed, but those very court-like things, the wig and the gown, are not there, probably designed to put families at ease. Some formalities remain, so you would still stand when the coroner enters or leaves the room, and you are still required to either swear on an oath on a holy book or give a non-religious affirmation before you give evidence. Some statements and some evidence that is gathered will be fairly non-controversial, and it might even be agreed by the parties. And if so, the rules do permit that sort of evidence to be read out. And if that's the case, you will be advised in advance by the coroner. You'll be told that your statement is going to be read, and what will happen during the actual inquest is that the coroner will read verbatim that statement out to the courtroom. But as you would expect, key evidence, any potentially controversial evidence, any complex evidence that is likely to be dealing with factors that may have caused or contributed to the deceased's death, will be given in person, and you would be expected to be questioned about that evidence as well. In terms of the order of events, the coroner would ask questions of you as a witness first, and then any of the interested parties would then be permitted to ask questions, and they would usually start with the family. You may have picked up from the previous sessions, the family of the deceased are very much kept at the front of an inquest. It's obviously something that is a very difficult time for a family, and the coroner's guidance is all geared towards making the family feel as included and as comfortable as they possibly can, given the set of circumstances that they're dealing with. Now, again, it will depend on the circumstances, but in some inquests, you would also have not just lay witness evidence, but expert evidence. More often than not, obviously, the post-mortem report, which can be read. But in complex cases where there might be some issues of clinical complexity or health and safety matters where you might need expert evidence, then that can be ordered by the coroner, and that expert evidence would usually follow the lay witness evidence. I've mentioned the term interested parties. You'll see the abbreviation IPs or PIPs throughout the slide, and you'll have perhaps seen it in other publications as well. That's what it stands for, properly interested parties. Obviously, that will comprise the family, but it would also include beneficiaries under any insurance policy or under the will. Any person who may, by any act or omission, have caused or contributed to the death, or whose agent or employee may have done. And the coroner actually has very wide powers, so anybody else who the coroner thinks has sufficient interest could be called as a properly interested party. If you or your organisation are ever made aware of a death and are not called as a properly interested party, but believe for some reason or other that you should be, then it would be as well to bring that to the attention of the coroner's office, because clearly you can't have any impact on the inquest itself unless you've given permission to be there as a properly interested party. Okay, so the coroner would open the inquest, and he or she would direct the police coroner's officer responsible for the case to start to collate a file of paper evidence. And obviously what that evidence comprises of will be tailored according to the circumstances surrounding the death. But the police coroner's officer will usually start gathering evidence from the family. The person within the family that has to give that evidence does not need to be the next of kin, but it would be somebody who knew the deceased very well. You would imagine it would always be the next of kin, and quite often it is, but there are sometimes reasons why that just isn't possible. It might be that they're just overwhelmed with grief and not in a fit state to be put through questioning. So it can be somebody that knows the deceased well. Okay, so let's assume you've been asked for a statement. Well, here again are some things that you might wish to just take note of. The first thing is that the civil procedure rules do not apply to the inquisitorial system. They have their own set of rules, and Ridwan did cover what these were on session 1, so I won't go into it in any great depth now. But there are various rules, statutes and regulations, plus guidance notes, plus law notes, which together comprise the rules of the Coronial Court. Some things will, however, have come up in civil procedurals if you're used to dealing with the civil courts, and will be familiar. So if your account is in any way proved to be untrue, you would still be at risk of perjury if your evidence, as I say, was untruthful. If you were deemed to behave in any way contemptuously, then you can still be fined for contempt of court. One particular slight oddity is that hearsay evidence is allowed. For those who aren't familiar with hearsay evidence, it's evidence that's heard secondhand that you do not hold within your direct knowledge. So it could be that you've overheard somebody else give a description about somebody or something, and you've recorded that. You've recorded that and discussed it as if it's your own words. It clearly isn't within your own knowledge, that would be classed as hearsay evidence. And normally that would be disallowed in the civil procedure rules. However, because of the function of a coroner, the function being to inquire into anything that is relevant to the death, they do allow hearsay evidence within the coronial jurisdiction. And of course, appropriate weight will be given to that by the coroner. I would say keep within scope. We're going to look at scope in a few minutes, but there will usually be, particularly in complex inquest cases, a pre-inquest review hearing. It's a bit like a directions hearing, and a number of things would be discussed, including whether there should be a jury, whether it's going to engage Article 2 and that enhanced level of inquest, who the properly interested parties should be, timetabling for various things, whether expert evidence is required, which lay witness evidence is required, etc. But one of the things that the coroner will also identify is scope. And what I mean by that is, let's say the deceased is 75 years of age. The coroner will not be inquiring into the last 75 years of that person's life. They will only be inquiring into a short time frame that is relevant. Now, depending on the circumstances surrounding the death, that can vary. So if the person was healthy up until a week before their death, and then something happened in a hospital setting, then the coroner is highly likely to just concentrate on that week prior to death. However, if it was somebody that was known to social care and had been for years and years, they might take the scope further back and look at 6 months prior to the death. So it will all depend on the circumstances. But what you must do when looking at how to give your evidence is make sure you keep within the scope for two reasons, really. One, everybody's busy and you don't want to be producing evidence that isn't relevant. But secondly, it helps focus everybody's minds, helps a jury, it helps the coroner if you can keep focused. Again, going back to how to help the coroner, they will really appreciate photographs and diagrams if they would help better explain your evidence. So if you're dealing with a complex arrangement of accident circumstances and a set of photographs would really help give a picture, then if you can annex them to your statement, I think everybody would be grateful. Same with diagrams if it was a road traffic accident or something like that. And if they're attached to your statement, it just makes managing the bundle at the actual inquest itself more easy. The coroner has the power to call and, in fact, summons a witness, and it's the general duty of every citizen to attend an inquest if they are in possession of any information or evidence that details how a person came to their death. A person cannot refuse to be a witness because they fear that their evidence might lead them being charged with an offence. Now, again, this will depend on the accident circumstances, but you can imagine if it's a domestic homicide or something like that, then criminal charges are likely to be brought. And there is a risk in some situations surrounding some deaths that criminality would be looked at. The rules make it clear that if the coroner requires you there as a witness, you must attend. But once you are sworn in as a witness, you can refuse to answer any question on the grounds of self-incrimination. And Rule 22 of the Inquest Rules of 2013 cover that. So there is some protection for you if you don't want to be making any admissions in a court of law which could prejudice criminal proceedings that may follow. One last little point on here, and it's too big a topic to cover in any great depth today, but there are some categories of documentation that are still protected and cannot or should not be disclosed. The obvious ones to think about are those where legal professional privilege applies, so your normal solicitor-client privilege. Some police reports can be withheld if proceedings are being contemplated. There are rules surrounding copyright and things like that. Too big a topic to deal with today, but just to make you aware that there are some things that would remain sacrosanct, as it were, or protected from being disclosed. So I've put on here a rabbit. This is designed to try and make sure you're still with me. Coroners don't like surprises. They don't want a rabbit to be pulled out of the hat. So if you believe you hold some evidence that is going to be relevant to the hearing, then it's as well to produce it in a format and with an explanation that everyone can follow. The coroner will decide whether or not something is relevant, and they can compel production of evidence. Generally speaking, all of the interested parties are entitled to sight of all of the relevant documents, but there are some exceptions, and I'm going to cover a case in a few moments that will give you a working example of where that might not be the case. But generally speaking, most of the people in the room will have had sight of the relevant documents. Some will be held back, so there are some special rules surrounding unpublished papers that are relevant, for example, a draft, serious case review, things like that. And there are, as I say there, the Rule 15 restrictions on disclosure. What, you might ask, is going to be relevant? Well, if you go back to what the coroner's role is, the coroner will deem any evidence relevant if it helps to establish the questions that the coroner is required to answer. So, who the deceased was, how the deceased died, when the deceased died, and where the deceased died. And of course, if it's the Article 2 inquest that John covered last week, how and in what circumstances the deceased died as well. So just to give you a bit of an example of things I've regularly seen when I've been attending an inquest, only some of these will apply, again, given a set of circumstances. But let's say it was a road traffic accident that led to the death, then you're highly likely to have photographs in there, a road plan, highway safety inspection reports, things like that. Possibly CCTV footage, body cam footage. If it's a death in custody, again, body cam footage. Anybody attending a murder scene or a serious crime scene would, quite often the police would be wearing body cam footage, so that could become relevant. If it was a death in a hospital institution or in some sort of medical care, you're likely to have the duty of candour reports from the NHS. If the deceased was known to social care, then you're looking again at social care records, adult social care records, commissioning of care, things like that. And then there are specific instances where you would also have overriding reports that you know are being prepared alongside the inquest. So if it was a death of a minor known to social care, then there would be a multi-agency serious case review underway, provided it met the threshold, and the same with domestic homicide reviews. Okay, so I'm just going to look at a couple of cases. They both concern Worcestershire County Council. I don't really know why, but that's just as it is. And the first one is this one, Worcestershire County Council, the Local Safeguarding Board and the coroner. It's a 2013 decision. And it's, well, I've set out really the basic circumstances of that case. But in a nutshell, this was a young lady, 16-year-old girl, Dana Baker, her name was, and she'd had a very troubled life. She'd been abused. She was suffering from mental health problems, and she had been removed from the care of her parents and had been placed into foster care. Her initial foster care placement had failed. She'd moved into a second foster placement, and at the time immediately preceding her death, that second foster placement had given notice. They were struggling to manage her, and so she'd been living with friends temporarily. As I've said on the slide there, I don't know whether you can see, terrible incident. She was found hanging in March 2011 in Kidderminster, and a serious case review commenced. Now, she was known to 16 different contributing agencies, and those 16 agencies were all asked to give an account of their involvement with the deceased. And that evidence was collated and fed into 10 IMRs and IRs. For those that haven't come across these before, an IMR is an individual management review, and an IR is an information report. And they are methods used by public bodies to collate information, you'll usually appoint an author, and he will or she will speak to all of the relevant parties and get some understanding of what their involvement was with the deceased prior to their death, what actions they'd taken, and ask them to reflect on practice. The inquest opened, because obviously this is a suspicious death, and the coroner requested not only the overview report, but also all of these underlying reports. Generally speaking, it's a bit of a funnel process. So all of the IMRs and the IRs are collated by all of these various different agencies. Somebody who is appointed as the overview author will collate the whole lot, review the whole lot, and produce one report, which is the overview report. And generally speaking, a version of that, highly redacted, is what is published by the Safeguarding Board at the end of the process. Now, the Safeguarding Board in Worcestershire were quite happy to provide the coroner with the overview report, but had grave reservations about disclosing the underlying reports. And this became a contentious matter. The coroner ended up applying to the High Court for permission to issue witness summonses for the documents, which was granted. The Safeguarding Board and the Council contested those summonses, and they were asserting that public interest immunity should override the public interest in disclosing them. And so we ended up with the two agencies being poles apart. So as I say, the Safeguarding Board were happy to disclose the overview report, but not these underlying reports. So the Safeguarding Board's contentions were that the purpose of a serious case review was not to inquire into how a child died, but for contributing agencies to identify and learn lessons to improve and better safeguard children. And actually, if you look at a lot of the literature around the purpose of a serious case review, that is entirely correct. It's designed to be a reflective process, a learning process where professionals can come together and, with the benefit of hindsight, look at practice and try and draw understanding and essentially try and prevent something happening again. And the Safeguarding Board very much felt that to enable that process to be effective and to reassure those contributing that they could speak with appropriate candour and honesty, they had to have received some sort of assurance that the contributions that those parties were going to make would not be made public. So they felt there was a clear public interest in protecting those IMRs and those IRs from disclosure. And in any event, they mentioned again that the overview report was entirely adequate for the coroner's purposes. The coroner, however, felt, in the circumstances surrounding this particular death, that those underlying reports would be essential to enable the coroner to identify relevant witnesses, lines of inquiry, identifying factors, one of which in particular was a request to further or better understand how each of the contributing agencies had interpreted their own child protection responsibilities and each other's fulfilment of their respective child protection responsibilities. So with any case such as this, obviously there are different agencies who are given different responsibilities, and the coroner was trying to unravel who should have been taking responsibility for what element. The coroner made it quite clear at the hearing that, and it was a he on this instance, he felt that an Article 2 inquest was merited, that the threshold was met. I presume that they were looking at systemic issues. It would have been appropriate anyway, because at the time the child was a looked after child. And the coroner also warned that a prevention of future death report was highly likely to follow. But the coroner did offer not to disclose the information any further until he'd managed to review it. And this does seem to have weighed very heavily in the balance when it came to making a decision. The case came before Mr. Justice Baker in June 2013 in the High Court. And he, having considered all of the material, and I should have mentioned at this point that these IMRs and IRs comprised 600 pages of evidence. Mr. Justice Baker had reviewed all 600 pages and had decided that disclosure to the coroner was appropriate. You can have a look at the case yourself, but the judge felt that there was significantly more detailed information in those IMRs and IRs than had previously been available to the coroner, and that it would be possible for the coroner then to frame the scope of his inquiry better and identify relevant personnel and lines of inquiry better. It sat with the necessity on the part of the coroner to undertake a full and fearless inquiry. Full, fair and fearless, you'll hear that quite a bit. But, and this is a big but, the judge did make it clear that nothing in his decision should be taken to indicate where the balancing exercise in relation to the public interest would fall should any members of the public, including interested persons at that inquest, request onward disclosure by the coroner. And he made it quite clear that would probably be the subject of a further hearing. Now, as I say, it should be remembered in this case that the judge had considered all of the material and had decided on this occasion that disclosure was appropriate. But there may well be cases where the balancing exercise falls in favour of the safeguarding board and the people contributing rather than on the coroner's side. And it will all, of course, depend on what the material consists of. In terms of implications going forwards, it's now probably going to be quite difficult for a safeguarding board to resist disclosure of IMRs and IRs to a determined coroner. But if you are here representing a safeguarding board, then please do think carefully before surrendering documents. That balancing exercise is still your responsibility to undertake. And there are instances where public interest immunity would apply and the decision would have been different. What this decision doesn't cover is whether the IMR should be disclosed further. And actually, subsequent to this decision of His Honour Judge Baker, the chief coroner at the time, who was Peter Thornton, published a law sheet, number 3, which I think is a January 2014 publication. And that quite clearly talks of a 2-stage test. And it's now going to be incumbent on parties, if there is this sort of contention, to have a second hearing. So you may disclose the documentation that's been requested by the coroner to the coroner, but the coroner would then give an assurance that it would not go any further, and it would not go further unless there'd been a further public hearing with all interested parties present to debate the merits. And at that point, the balancing exercise would be undertaken. So quite an interesting case to know about and to have in your back pocket, as it were, especially if you, as I say, if you're coming from a safeguarding board background. Okay, I hope you're all still with me. Another case. This is to do with reporting restrictions and redaction, and it's really a bit of a lesson in how not to go about it. To give you some of the background to this, and this is a recent decision, this is a 2019 case. AB, in this case, was a 17-year-old who took her own life in custody. She had been separated from her siblings, and various of those siblings were still in care. And it became apparent that this inquest was likely to explore allegations of sexual abuse, which could be very distressing to 2 of the surviving very vulnerable siblings who were in foster care, struggling with their own grief, and who did not know the manner of their sister's death. For very honourable reasons, clearly honourable reasons, Worcestershire County Council sought a raft of reporting restrictions, and they sought to prevent publication of the identity of the deceased, her parents, her siblings, their parents, and the local authority. This case, I think, serves as a lesson on how not to apply to court for reporting restrictions, and thereby it highlights what you should or shouldn't be thinking about if you need to do so. It's a bit unfortunate, but if there is an inquest, then it's just set out in all of the regulations that the deceased must be named. And also the inquest must be made public. And the only exception to either of those things, I would say, is if there is something of high national importance that would mean that you shouldn't do either of those things. But it would have to be that serious. So national security at stake, risk to life, something like that. The council went about this all wrong, unfortunately. The council gave no notice of the application. So they gave no notice of the application seeking to prevent publication of the identity of these personnel to the deceased's parents, to the NHS trusts that were involved, to another local authority. It was effectively done on an ex parte basis. They did give limited notice to the media. That was the Press Association and some local newspapers. But information provided to them was very scant, to the extent whereby they didn't really know what this application was about. They couldn't work out what it was likely to be entailing. I've put here, it was a very bold attempt on the part of Worcestershire County Council, and quite surprising given that there is guidance available to read, but I'll come to that in a moment. But unfortunately, they made the wrong application using the wrong procedure, and they issued it in the wrong court. The only benefit was that the whole thing was ex parte, so they did save some costs because not everybody attended, but it's little comfort really. They brought the application, for those who wish to know, under the Children and Young People's Act. That is an act that has a provision in it, Section 39, which is intended to protect the identity of child witnesses, but it cannot protect the identities of children who are neither parties nor witnesses to an action, and it certainly can't protect the identity of the deceased. So it was always going to fail on that basis. Should you have a case with similar facts, you could potentially consider using Section 1 of the Sexual Offences Act, but on this case it wasn't used. It was the wrong procedure because any determination could only ever have been determined at a hearing where both sides were represented. Inquests are public hearings. The rules are particularly strict, particularly when you're looking at Article 10 rights. So those are your rights for freedom of expression. Anything that seeks to quieten or hide evidence in an inquisitorial process is always going to be met with the utmost scrutiny. So doing this on an ex parte basis was incorrect, and it was in the wrong court. The application ought always to have been made by the council to the coroner, not to the High Court. And the guidance note that I was referring to just a few moments ago is Chief Coroner's Guidance Note 25. It's headed up Coroners and the Media, and this would have given some assistance. Having realised that they were in the wrong court, they then sought to try and seek the High Court to engage its inherent jurisdiction, having put oral submissions forwards, to try and get the court to do the balancing exercise between the right to family life, which is the Article 8 element of this. They were trying to protect the family, against the Article 10 right of the press and the public at large to have a public inquest. But again, because it was on an ex parte basis, it wasn't going to happen. And actually by that stage, they were also in the wrong division of the High Court. They needed to be in the family division, and they were in the Queen's Bench division. So all in all, it was a lesson in how not to do things. And His Honour Judge Pepperell, who presided, said justice is not done by one party enjoying privileged access to the judge and placing before the court evidence and argument that it is not willing to share with other parties. And I think that's the takeaway from this, really. Unless there is something of high, serious nationwide importance, you are highly unlikely to be able to do hearings and impose reporting restrictions. And if you think you have a case, you certainly shouldn't be doing it or bringing that application on an ex parte basis. If you're interested in what would meet the threshold for freedom of expression sort of workaround, then you're looking at Section 12.2 of the Act, and that sets out when and if you may look to withhold disclosure or impose reporting restrictions, and it makes it quite clear that no such relief is to be granted unless the court is satisfied that the applicant has taken all practicable steps to notify the respondent, etc., etc. Again, it's a different subject for today, but it's all there if you wish to read it. And as I say, the takeaway really is that secrecy is not supported unless there are very good reasons, such as national security or a threat to life. Okay, I'm just going to whiz through a few more slides just to end off our evidence section. Rarely do inquests happen in isolation. They can, but quite often there are other processes running alongside. And I've just noted 3 here just to show you what might happen if they are also running and coexisting. So if you had a complaint, an internal complaint running alongside the inquest, then the coroner will not be particularly interested in that. They will not wait for the outcome. They will just proceed with the inquest. So you can put that to one side. Civil claims, quite often a civil claim will be placed on hold pending the outcome of an inquest. We'll come to why in a little while. But of course, the outcome of an inquest can have a significant bearing on a civil case. And particularly if the family are wishing to bring a Human Rights Act claim, then they only have 12 months to do so. Unlike the Limitation Act, the limitation period for the Human Rights Act is only 12 months. So on a personal injury claim, you would have 3 years, generally speaking. On a Human Rights Act claim, 12 months. And that applies whether you're a child, whether you're operating under a disability. There's no dispensation. So it's quite likely that if you're dealing with a complex set of circumstances surrounding a death, that the inquest will not have been listed within that 12-month period. That being so, a family have to make a decision as to whether they're going to issue proceedings within the 12 months and risk the cost of so doing, or whether they'll just seek a moratorium, which is basically a stay. And if the parties agree to that, that can be done. Criminal proceedings are often put on hold until, criminal proceedings are often allowed to run and the inquest put on hold pending the outcome of the criminal proceedings, simply because if someone is found culpable and a verdict is given, then the questions that the coroner has to answer have already been answered by the criminal trial, and then the inquest can become unnecessary. Going back to the point I was just making, inquests can and do impact civil claims. I'm sure Ridwan and John have covered that they shouldn't, insofar as they are not adversarial, they are inquisitorial. The fact remains, however, that inquests are designed to be a full, fair and fearless inquiry, and they will expose the full facts leading up to a death, any deliberate wrongdoing, any systemic dangerous practice, any deficiencies, any conduct which is discreditable. It will expose failures on the part of any state body if they've failed to protect life, and the conclusions that can be given can highlight factual failures, and they will state that they caused or contributed to the death, and sometimes in quite stark language. So you can imagine that grief-stricken families and their lawyers will use an inquest to glean all sorts of useful information, evidence of poor practice, individual failings, mistakes. So whilst it is true that they are not inquisitorial, you do have to be mindful of the fact that they could have a bearing on a civil claim that is lying behind. In terms of that conclusion, when all the evidence has been heard and submissions have been made by the lawyers acting for all the various interested parties, if they are represented, or by representatives from those organisations, then a conclusion will be given. If there is a jury, the coroner will sum up first before sending the jury out to deliver a conclusion. If there is no jury, then it will be the coroner who delivers that conclusion. And John did cover how the wording of non-jury conclusions might be about to change given the case of Smith. As I say, do tune into John's talk. He did an excellent article on it last week. But some of the language being used has got to be tempered a little. My point really is that you want the conclusion to be the right one, and you want to make sure that the evidence that the court needs to hear has been heard, and therefore it is incumbent on you to engage with the process. Okay, so I've put up Lord Baden-Powell. I don't know how many of you have ever been in the Girl Guides or the Scouts, but the Be Prepared motto was ingrained on my brain as a child. And Baden-Powell says that the meaning of the motto is that a Scout must prepare himself by previous thinking out and practicing how to act on any emergency or accident, so that he is never taken by surprise. And I suppose that is my message today. My closing thoughts on evidence really are that I would ask that if you're asked to give a statement, please consider your words very carefully. Consider the content, whether any of it needs to be redacted, the form of that and how you disclose it. If you feel your organisation is likely to be criticised in some way, then seek legal advice at an early stage so that that can be considered in the round and witnesses prepared properly. Anticipate weaknesses, analyse actions. These sort of pointers really apply whether you're facing a straightforward inquest, complex Article 2 inquest, even deaths abroad. We've dealt with all of them as a firm. I would always say thoroughly prepare, especially where you think civil claims or Human Rights Act claims might already be sitting in the wings. Keep your evidence within scope. And when I say anticipate problems, I've had cases where we've had trouble tracing witnesses because they were agency staff or retired staff. Getting those witnesses engaged, getting them prepared, preparing them for what is a nerve-wracking experience is all time well spent. Early identification of hostile witnesses. I attended an inquest a couple of years ago where there was a dispute between the mental health trust and the mental health nurse. And because they couldn't agree, they ended up being separately represented legally. So that's one thing that we do need to bear in mind at an early stage. And if you're aware of gaps in your evidence and you're at risk of a PFD report, then obviously think about where those gaps are, admit failings where necessary at an early stage, but always, always, always check with insurance before you do so, please, to ensure that that doesn't prejudice any of your policies. Engage with the process, attend the pre-inquest review hearings, get your point across, make sure your organisation's position is protected when issues are being discussed, such as juries and Article 2, etc. Make sure where appropriate that you're liaising with your insurance department and your media and comms, because some of these witnesses, some of these cases and some of these inquests will attract media coverage. We've had that in a number of cases. So you need to be managing your reputational damage, etc. So we've finished evidence and we're going to move on to Regulation 28. Please, if you need to take a slurp of something, do so. Stretch your arms, stretch your legs out slightly. This section is much quicker. Most people groan at the thought of a Regulation 28 report. It's not something that anybody wants to receive. They do fill most people with dread. That is what Regulation 28 says. It's there on the slide for you. They used to be known as Rule 43 reports, and they were replaced by the Coroners and Justice Act of 2009. If we start to look at what it says, then the guidance notes say that the coroner has a duty not just to decide how somebody came by their death, but also, where appropriate, to report about that death with a view to preventing future deaths. And the coroner's guidance is quite clear in explaining the purpose, really, of a Regulation 28 report. And the guidance says that it should be that a bereaved family can say at the end of an inquest, where there's been a PFD report, that whilst their loved one's death was tragic and terrible, at least it shouldn't happen to somebody else. And that's really what drives a coroner to produce a Regulation 28 report. So it's a safeguarding mechanism. Coroners take this duty very seriously. There are 600 plus PFD reports issued every year. You're most likely to see one following an Article 2 inquest, but not exclusively. The coroner will often publicly announce his or her intention to make a PFD report and give some indication of the likely substance of that report. And in fact, when you think about it and you look at the obligations on the state and the Article 2 obligation that the state must protect life, then the coroner's remit here is a way of very effectively discharging the procedural aspect of the state's Article 2 obligation. So it's a way in which the government can prove that it takes the right to life very seriously. Submissions either way between an organisation and the coroner are done electronically, so there's no paperwork involved, and the submissions will go backwards and forwards. So when will this happen? When might you get one of these? Well, having conducted the investigation into a person's death, something will have been revealed, either in written or oral evidence, which gives rise to a concern that a set of circumstances, still exists that could expose others to loss of life in the future. And that's the key thing there. There's a set of circumstances giving rise to a concern that still exists. It's a fairly low threshold. The coroner must believe that action should be taken to prevent a recurrence of the circumstances or to reduce the risk of future deaths. And very interestingly, the coroner isn't restricted to highlighting matters that were causative of the death of the subject of the inquest, but can report incidental or peripheral concerns. And the guidance notes give an example of this because it's a bit difficult to explain, but imagine that the police, whilst investigating an incident that leads to a death, search a property, and in the course of that search they find, as well as the suspicious death at the property, firearms in the deceased's home. Whilst undertaking that search, even if firearms were not causative of the deceased's death, but evidence at the inquest raises questions about the sufficiency of police authority fire checks and certification processes, the coroner could make a PFD report. And it wouldn't have been causative of the death of the deceased in that instant case, but it's because they feel like there are some systems that are dangerous out there in existence that need addressing. The report will be issued to all persons or organisations who are believed to hold power to take action to change things. And in terms of what would need to change, well, it would be with a view to improving the public's health, welfare, or safety. So that's the purpose. The guidance notes, and I quote, say that in the past, some coroners have from time to time expressed themselves in public with forceful language. Phrases such as "I am appalled" or "I am disgusted" or "shame on you" have been used, and they should not be used. Coroners should at all times use moderate, neutral, well-tempered language befitting the holder of judicial office. So there is clear guidance there on what the tone should be. It should be factual, it should be to the point and succinct. Coroners, in doing these reports, should avoid sweeping generalisations. Any highlighted concerns should be meaningful. The language used should be neutral. And wherever possible, they should be driving an organisation to look at some practical outworking to improve health, safety and well-being. It's an obligation on the coroner to produce these reports. It's not just at their own discretion. Reports should not be seeking to apportion blame, be defamatory, prejudice law enforcement action, any of the things listed there. Interestingly, the coroner cannot tell an organisation what to do, and the coroner cannot dictate policy. They can highlight the concern, and it is then left to the organisation to whom that report is addressed to take the recommended approach. And they are highly encouraged, I would say, to review processes, review policies with a view to making changes if they are possible. I mean, it might be that a change isn't possible, but that's the intention. Okay. So what might it say? Well, it might say something like, you should consider a review of your procedures on safety and the use of ladders, or a review of the methods of communication during live military fire exercises, etc. I did in fact have a quick look this week on the judiciary.uk website where these PFDs are published. And on the 18th of May, I can tell you that 10 different PFD reports were published up and down the country, covering innumerable different circumstances. So just to give you some idea, there was a mother and daughter who had been murdered effectively, and that was a shotgun incident, and the PFD report was addressed to the police, who were asked, very much like this one, to look at certification processes for that shotgun. A license had been renewed, which perhaps shouldn't have been. There was a child death, newborn, due to midwifery failings, so that was going to be looked at. There's one addressed to a GP who had failed to prescribe meds properly, failing to take into account alcohol problems. So again, a PFD had been reported there, with a view to looking at prescriptions and the process around prescribing. There was an incident where a straw bale had hit a farm worker on the head, fallen off the back of an HGV trailer. So that's obviously going to be an accident at work. There's a highway safety case there where there were some issues surrounding the safety of a crossing near a school and the lack of barriers and signage. There was a failure to chart deteriorations in the care of an elderly person in a care home, a nursing home. Another one was communication failures within a hospital setting. And another one was a very sad young person's suicide. And again, that was to do with prescription of lithium and communications between doctors and psychologists. So these PFD reports can cover innumerable matters, but that was just a taste for you from one day this week. And they look like this. You would get something like this through the post. That's just an excerpt, or through the email, I should say. It's electronic. And it's requiring you to undertake a review. It's usually a Word template that coroners are expected to use. If you're on the receiving end of one of these, what do you do? Well, you should receive it within 10 working days of the end of the inquest, or within 10 working days of the time that the evidence came out, giving rise to the concern. And by the time you receive one, all interested persons will have received one. The chief coroner will, and all other interested parties. So if it was a death of a child under 18, the local safeguarding board would have been advised. If it's a death in custody, then the Inspectorate of Prisons would have been informed. If it's a road traffic accident, the Department of Transport, etc. The guidance very much recommends erring on the side of openness, so probably more agencies would be notified than less. And once made, the coroner has no power to withdraw that PFD report. And that's why really it is so essential that you engage with an inquest and get your evidence in if you feel you're at risk of receiving one of these. Because if you don't and findings are made, then it is a done process, and it can make it very difficult to defend actions thereafter should a civil claim arise. Your response will also be published. So not only is the Regulation 28 report published, but the actual response, and you have 56 days to reply to it. The response should be sent to the Chief Coroner electronically. As I've said there, they are published. Just occasionally, if it's a very serious matter, some of those reports might be taken further, and it might lead to changes in legislation. It might be reported at central government level. They can be taken very seriously, obviously not in all situations and circumstances. But a chief coroner can give advice to a government or to an organisation to recommend changes to themselves or in the law, as I've said. Okay, we're nearly there. 2 slides left. So, implications for litigation. Well, a PFD report can be problematic. We've obviously said why. It can highlight weaknesses, it can highlight potential failings. It's true that you can't change history. If someone has died in a set of circumstances where there were gaps in the evidence or gaps in processes, there's nothing really that you can do to change that particular outcome. However, it is entirely possible for an organisation or an individual to present to the coroner and to the family of the deceased an improved picture, and in so doing reassure parties that it's being taken seriously, that actions are being thought about and revisions are being made. And so whenever we have acted for clients on these sorts of matters, we've always tried to recommend that there is some personal reflection at senior level of what could be done differently. And we've had various incidents. I mean, it might be that you strengthen your emergency duty team processes if you're a local authority. It might be an issue of supervision of staff. It might be an issue of access to other agencies' data, multi-agency sharing of data. It might be a training issue. It might be a policy that's outdated. It might be a recruitment issue. All of these are things that we've seen in the past. And we've got quite a lot of experience in the team of drafting responses and liaising with organisational leaders to address some of these concerns. I would always advise that a Regulation 28 response is produced by someone senior. I think even before that, if you know you're at risk of receiving one of these reports, get somebody within your organisation, AD level or above, managerial level, to show that those lessons are being learned, and to produce a statement and to produce an action plan. And if you're going to produce one of those, what strengthening work is being done, what's the scale and scope of it, what time frame is being applied, who's driving it, who's auditing it, make it look robust. And quite often, if you produce that before the end of the inquest, then a PFD report will not follow, because you have reassured the family and you've reassured the coroner that all that could be done is being done. They do work. All I would say is that if you say you're going to do something within a timescale, then please do it, or explain very clearly why it hasn't been done. What you don't want to be doing is making promises that you can't fulfill. And the worst case scenario altogether is repeated PFD reports highlighting the same problems, because it just paints a very dismal picture and makes problems for an organisation. So I hope that gives you some understanding of evidence and Regulation 28 reports today. I must thank you very much for listening. I know it's a very warm day and you're probably all desperate to get out into the sunshine. I hope you've found it helpful. If there's anything that you've heard today that you want further information about, or indeed on any of the previous sessions that Ridwan and John have done, please do get in touch with us. The slides will follow for those that have requested them, and I will end matters there. Have a lovely rest of the week, and thank you for your time.